Welcome to another episode on the Law Report. Today, I would like to discuss disclosure in criminal cases. As a matter of disclaimer, this is not legal advice, should not be construed as such. For legal advice, please contact a competent attorney. Disclosure is a vital part of every investigation and the preparation of every case for prosecution of trial. An efficient and properly conducted system of disclosure in criminal cases is fundamental to the fair system of criminal justice. The duty to disclose in the Turks and Caicos Islands was a common law duty until the enactment of the Criminal Procedure Rules in 2021, which came into effect on the 4th of August 2021. The rules set out a disclosure regime, including an obligation on the defense to provide a defense statement. This is a novelty in the Turks and Caicos Islands, and I will deal with these rules in a subsequent episode. Disclosure in criminal cases is the principle requiring the prosecution to disclose material it intends to rely on at trial and material capable of assisting the defense in knowing the case against the defendant, thus helping the defendant to prepare his own case. So to be clear, disclosure is providing the defense with copies or access to all materials that are capable of undermining the prosecution's case and or assisting the defense. Investigators, prosecutors, defense counsels, and the court all have an important role to play in ensuring the disclosure process is done properly and promptly. When an allegation is made to the police against someone, the police is expected to conduct an investigation. At the beginning, at the very outset of this investigation, the police have a duty to retain, to review, and to record all materials collected during the course of the investigation. This material should be revealed to the Office of the Director of Public Prosecutions or to the prosecutor with conduct of the case to allow for effective disclosure to the defense. The police have a duty to conduct a thorough investigation, to manage and secure all materials, and to follow all reasonable lines of inquiry, whether they point towards or away from the suspect. In the event where a person is charged with an offense, the prosecution is under an obligation to review all materials gathered during the investigation, such as CCTV footage, statements from witnesses, mobile phone messages, social media conversations, and photographs. The prosecutor will then decide which items collected during the investigation will form part of the case, or in other words, if they are relevant to the issues in the case. Some materials may be relevant to the case, but the prosecutor may conclude that these material do not take its case any further, and so the prosecutor may decide they should not form part of the Crown's case. This is called unused material. Notwithstanding, the prosecution or the prosecutor may form the view that the unused material will not be part of the Crown's case, the prosecutor is still under a duty to disclose this material to the defense. In the case of R and H, 2004, a House of Lords case, Lord Bingham said the following, and I quote, "Fairness ordinarily requires that any material held by the prosecution which weakens its case or strengthens that of the defendant, if not relied on as part of the formal case against the defendant, should be disclosed to the defense. Bitter experience has shown that miscarriages of justice may occur where such material is withheld from disclosure. The golden rule is that full disclosure of such material should be made." End of quote. Although there is an initial duty of disclosure on the prosecution, the duty is a continuing one and does not conclude until a verdict has been reached in the case or the matter is discontinued. Thus, the duty lasts until the end of trial. And this was confirmed in the case, an application of none and Chief Constable of Seoul for Constabulary, and another case that was decided in 2004 by the United Kingdom Supreme Court. Early disclosure is very important as it could assist in the early resolution of matters. In cases of bail hearings, disclosure will assist the defense in answering concerns raised by the prosecution where there is an objection to bail. A person charged with a criminal offence, appearing for the first time in the magistrate courts, should be provided with some measure of disclosure at the initial stage to enable him or her to know the case against them and to assist them in making an informed decision whether or not to plead guilty or not guilty. Early disclosure also assists the attorney in advising his client properly. Therefore, anyone charged with a criminal offense should contact an experienced attorney who understands the challenges and difficulties of criminal proceedings, including issues of disclosure. Why? There are many cases throughout the English jurisprudence where cases have been stayed as an abuse of process due to the lack of disclosure. In some of those cases, the court held that it would be unfair to proceed against the defendant. Or in other cases, the court held that in the circumstances, it will be unfair to try the defendant because he will not be able to receive a fair trial. That is because the matters that were not disclosed or the material that were withheld was central either to the defense case or they were central to the issues in the matter. And as a result, the court stayed these proceedings permanently. Thank you.